Clerk Neely, will you call the next case?
SJC-12874, Commonwealth.
Now exiting.
Assistant District Attorney Michael McGee.
Commonwealth v. Lee, Ashford.
Emil Otto.
We have Mr. St. Lawrence. Mr. St. Lawrence, if you're there, you may need to unmute.
Good morning, Mr. Chief Justice. And may it please the court?
Yes, please.
Thank you. We raised three issues in this appeal. In my opening remarks, I'll focus on just the first issue. In Brown, this court held that a conviction under 10N required proof that the defendant knew that the firearm he possessed was loaded. We submit that due process requires that Brown be applied retroactively to Mr. Ashford's case, which is here on collateral review. We take issue with the Commonwealth's argument in its brief that retroactive application of Brown would be unfair to the Commonwealth and would unjustly burden them to fathom future deviations from existing law. Brown was not a new interpretation of 10N. Brown simply interpreted the meaning of that statute since its enactment in 2006. Significantly, Brown did not overrule any published opinion from this court or from the appeals court. And in Eberhardt, which was decided in 2012 by this court, the court expressly noted that it was an open question whether 10N required proof of knowledge. By the time of the trial in this case, the writing was on the wall that 10N required proof of knowledge. In addition to the fact that the existence of mens rea is the rule in criminal law, and that the plain language of 10N supported that knowledge was required, this court concluded in Johnson in 2011, before the trial in this case, that 10H, which prohibits the knowing possession of ammunition, was a lesser included offense of 10N when the only ammunition was found inside the firearm. So the court's holding in Brown was based in part on Johnson, because if the lesser included offense of 10H required proof of knowledge, it logically followed that the greater offense of 10N required that same proof. Thus, Johnson, which was again decided before the trial in this case, foreshadowed the court's holding in Brown. And for these reasons, retroactive application of Brown to this case is fair, and it does not prejudice the Commonwealth. I see I only have a couple seconds left, so turning very briefly to the sufficiency of the evidence that Mr. Ashford knew that the firearm he possessed was loaded. We submit that the Commonwealth's argument in its brief proves too much. In essence, the rule proposed by the Commonwealth would be that mere possession of a firearm proves that the defendant knew it was loaded because firearms are possessed for protection. That cannot be right, or the additional element of knowledge that the firearm was loaded, which carries substantial additional punishment, would be meaningless. So with that, I'd welcome questions from the court.
Justice Link.
I'm looking at your third argument in your brief, that it says in the event that we affirm the denial of the motions for required finding of not guilty, we should nevertheless reverse the denial of the motion to vacate an unlawful or unlawful sentence where his client's sentence for the offense of unlawfully carrying a firearm was enhanced into two separate sentence enhancement statutes. I presume that you're saying that 10N is a sentence enhancement statute alone?
That is, our position is that 10N is a sentence enhancement statute.
And that's all it is?
And that's all it is, and then...
it's not an independent crime?
It's not an independent crime, in our view, and under the cases from this court. You would have to have...
Which cases are you referring to under our court that say that it's only a sentence enhancement?
Well, I guess I don't have a case that says, that's decided that it's only a sentence enhancement, but I think it has to probably be one or the other. And in Brown, the court said that because the further punishment language and the on and after language, that you can't have a 10N alone. You need a conviction under 10A in order for a 10N to operate. And for that reason, it's a sentence enhancement.
Mm-hmm. Okay, but that's not what the statute says, is it?
The statute doesn't say, specifically that this is a sentence enhancement, but not many statutes, I don't think, label themselves as that.
Well, do you see the similarity between 94C, 32J, and 10N?
Do I see a difference?
Or a similarity?
They're similar in the way that they're structured, with the on and after penalties for a underlying conviction. I think they're different, though, in that 32J specifically. Let me back up. I think they're different in regard to my argument here today, because 32J specifically, it expressly allows for double enhancement, because the language in 32J doesn't specify specific violations of 32A, B, C, D, E. It says all of them. And so where a defendant is convicted under 32 of an underlying possession with intent, and then also as a subsequent offender, he can be doubly enhanced. It's clear in the 32J statute, whereas it's not clear in the 10N statute, because 10N does not reference 10D, which is the subsequent gun offender statute, and it doesn't reference 10G, which is the other enhancement in this case. So I would point to 32J and say, this is an example, 32J, of an express and unequivocal intent of the legislature to allow for double enhancement. They knew how to do it in 32J, but they did it differently in 10N. It says 10A or it says 10C. It doesn't say 10D, which would be the subsequent gun offender enhancement, and it doesn't reference 10G. So that's why we say it's ambiguous as to how these operate together, and why one of them would have to be vacated only in the event that the court disagrees with us on both of the first two issues.
All right. Okay. Thank you.
Thank you.
Thank you, Chief. Just one question on retroactivity, and I take your point that usually statutory interpretations go back to an enactment, but here, would you address the argument that it is a new rule and only applicable for cases on direct review, not collateral review, where there's no judge in the world that was instructed on knowledge in this case, and it was kind of taken as an assumption that it wasn't there. That was the practice in the courts. Could you address that, please?
Sure. It certainly does appear that was it was almost taken as a given, as Your Honor said. But I want to just refer back to some of the clues that were out there as early as the enactment of this statute. I would say that knowledge was required. So just because it was taken as a given, I don't think is a reason to say that it should not be applied retroactively. There was really no decision interpreting it that way. Of course, as you say, it was taken as a given. But even if it's a new rule, I think even if the court were to say, because the bar and the judiciary all understood it this way, and therefore it's a new rule, which I do think would be incorrect. But even if you did that, I think it still should be applied retroactively, because it changed the criminal conduct at issue that's covered by 10N. And when new rules are substantive like that, where they narrow the range of conduct upon which a person could be convicted, that in the normal retroactivity framework, that new rule would still be applied retroactively even to cases on collateral review. So I think either way, we would ask the court to apply it to Mr. Ashford's case.
Thank you. That's all the questions I have.
Thank you.
Justice Louis.
Thank you. I'm going to ask you about 10N, but not in terms of retroactivity or even the issue of whether there's a substantial risk of miscarriage of justice because of the lack of the instruction on knowledge. I'm more interested in the required finding issue. And the argument for the Commonwealth is not, well, he merely possessed a firearm out in the world, so we can draw an inference, or that is enough to show that it's loaded. Their argument is that with expert testimony, that guns and drugs go together, and in fact, in this case, the guns and drugs are together. And the purpose of having a gun for a drug dealer with the testimony in this case is enough to survive a required finding. Why isn't that in conjunction with the gun's purpose enough to survive a required finding?
Well, there's a couple points on this. I think number one is that why does anyone, I guess it begs the question, why does anyone unlawfully possess a firearm in public if not for protection? We have an issue with, I think, with that inference and whether that is strong enough to bear the weight of proof beyond a reasonable doubt.
Well, it's in my view, it's certainly not enough for sufficiency. But here, whether that inference is available or not available to add to the calculus, I'm not sure how important that is for this case. But that's not the Commonwealth's position. Their position is that it's because backed up by some expert testimony that a drug dealer, if they're going to take a gun out for protection, they're going to have it loaded. Not just anybody.
Right. And so that the expert testimony on that was scant. I'm referring, to Record Appendix 223. It's basically one question and answer, and it's in your training and experience in the city of Brockton dealing with narcotics investigations, is the use of protection significant in any way? And the expert answers yes, it could be. The other point is, factually, the gun is not within, apparently it's not within Mr. Ashford's reach in the car. It's in the back seat of the car and it's in a bag. Also, apparently I believe the testimony was that there was not a bullet in the chamber, so it would have taken another move in order to get that up and ready for protection. So that's kind of our position on, it definitely can be taken into account, but I don't think the constellation of facts here is enough to get it over the threshold to be proof beyond a reasonable doubt that he knew that it was loaded. And that's why I said earlier that it kind of begs the question, though, of how far are we going to take it if we go this route? Because why does a person unlawfully possess a firearm in public if not for protection? You know, it almost could be used in any situation, which which would then eliminate the element altogether.
Well, I agree with that. I mean, if I don't know, if the inference is not enough for sufficiency in and of itself, but when you talk about the gun and the drugs being outside of his reach in the back seat, that would be an issue. Except that from the Commonwealth, like the state of the Commonwealth, he also had the drugs outside the car.
Right. I guess he had those on his person when he fled. But the case I would say is closest on the facts is out of the appeals court, a case called Galarza. And so that person was by himself at nighttime, like Mr. Ashford, and he had the firearm within the center console of his truck, so it was within reach. Again, if we're going to start citing the nighttime and the daytime, Galarza was 1:50 a.m. Our case is 9:15 p.m. And the appeals court found that evidence was not enough to meet the knowledge requirement. So I think that's our best case. I think it's pretty close. Of course, we don't have the drug aspect in that case, but that's the case we would point to as the closest.
Thank you.
Thank you.
No questions.
Justice Seifer.
No questions. Thank you.
Justice Kafker.
Just one question. The retroactivity issue, I'm just not sure how it works when we're dealing with an element of the crime. The cases that say we don't apply a new rule retroactively, do they apply to cases in which the new interpretation involves an element of the crime?
If the new rule, in our view, if the new rule narrows the breadth or the scope of criminal liability, which this does, because it goes from a strict liability crime to an additional element of knowledge. In that case, that's if it's called a new rule, which we don't agree with, but if it is, it's a new substantive rule. And that type of rule is always applied retroactively on collateral review. So I think there was even a case I cited from this court in the brief called Henson, which I think narrowed criminal liability I think it was one of the maybe a assault with the intent to murder cases. I can't remember right now. And the court applied that fully retroactive to other cases because I think it's a fairness idea. If you were convicted on less than proof beyond a reasonable doubt, then we can't allow that to stand unless we go review that and make sure that the new element was satisfied by the evidence. And if it wasn't, or if the jury wasn't instructed and the evidence wasn't so overwhelming that the element was ineluctable, or I don't know if I'm pronouncing that correctly, then we have to reverse that conviction. So
Henson involved, I'm just looking at your brief, it was a specific, we made clear there was a specific intent to kill element that wasn't previously present. I haven't read Henson in a long time. So is that what we did?
Right. And then in a future case after Henson, or maybe Henson was the case that applied it retroactively. I don't know what the case was. Yeah, that switched it, or that added that element. I can quickly try to find it in the brief.
I found it. It's on page 17 in your brief.
Okay.
Yeah, I'm just pulling up Henson right now. Okay. All right. That's all I have. Mm-hmm.
Okay. Thank you, Your Honor.
Chief Justice Gantz. Am I correct that pragmatically for your client, the ball game rests with the ACC issue as opposed to the 10N issue was interesting and important, but it was probation for 2 years on and after, correct?
Right. So he's still incarcerated on the 10G ACCA. He
right.
has about 9 months. He has about 9 months left on that sentence.
Okay. So,
and then.
Oh, I see. So, but let's discuss. You're arguing that he should not have been found guilty on the ACC because ABDW is not a violent crime, correct?
Right.
So we have Eberhardt, which came in the context of not ABDW, but just AB, and we said, well, it could have been an offensive battery, and therefore, since we only know that he was convicted of A and B, we can't say it was a crime of violence. But we did say that intentional battery and reckless battery are crimes of violence. And then we have the First Circuit, which has come to a different view. Is the language of our ACC the same as the federal language, or are there differences in the language of the definition of a violent crime?
It is essentially the same. It's the use of physical force against the person of another. I believe the Massachusetts ACC adds in or a deadly weapon. I don't believe that's present in the federal ACCA. But other than that, it tracks pretty much right on. I think that was the basis. The federal one was the basis for what Massachusetts did.
And do we know? I guess all we have here is the conviction itself. We just have the certified conviction, correct?
Yes, there was a packet of basically a docket entries and the indictments from the ABDW.
And do we know what the weapon was that was used in that crime?
I think in the packet, in the indictments, it references a 2-wit metal chain.
A metal chain?
Yeah, a metal chain is all that is apparent from the evidence that was presented.
Okay, so essentially, we have to struggle with your argument and the First Circuit's argument that if it's reckless, it's not against the person of another, versus our ruling in Eberhardt, correct?
Right, and that's what we think kind of changes it, is that in Eberhardt, this court really relied on an appeals court decision called Cologne, and that decision didn't. I kind of word searched it, and it only comes up in Cologne and in Eberhardt against the person of another. Only comes up when the court is quoting the statutory language. So our position is the court never really grappled with that part of the plain language. So use of physical force, if you're only looking at that, you can see why potentially reckless conduct would fall under that language. But when you read it with that restriction of against the person of another, our position is that limits the statutory language in a way that doesn't encompass reckless conduct, because reckless conduct is not targeted at the person of another. It's reckless. You can be unaware. You can be convicted of reckless assault and battery with a dangerous weapon without even being aware of the risk of serious injury.
Okay, I have no further questions. Any other justice have a question? And hearing none, so we'll turn to Mr. Nivens.
Thank you, Mr. Chief Justice. May it please the Court, Patrick Nivens for the Commonwealth. Your Honors, the Commonwealth respectfully requests that this Court affirm the motion judge's decision to deny the defendant's motions for required finding of not guilty and his motion to vacate an unlawful sentence. As to the first issue on retroactivity, the new statutory interpretation of Chapter 269, Section 10N, as applied in Brown, does not apply retroactively to the defendant's case because this court is not constitutionally required to apply a new statutory interpretation to cases on collateral review. As this court pointed out in American International Insurance, prospective application is appropriate when there's been a substantial departure from prior precedent. And here there has been a substantial departure from the existing common law at the time. A mens rea did not attach to aggravating factors, whether that was weight of drugs or school zone limits, but rather attached to the underlying crimes. In addition, with this case being on collateral review, there's principle of finality that Justice O'Connor talks about in the Teague case, which this court adopted in Bray. That finality plays an important role in the criminal justice system, particularly with its deterrent effect. But even if this court does decide to apply Brown retroactively, the Commonwealth did present sufficient evidence, and the failure to instruct the jury was not a substantial risk of a miscarriage of justice. As to the issue on the assault and battery with a dangerous weapon and whether that's a violent crime or not, the appeals court in Widener highlighted how this court has already weighed in on the matter. As has been said in Eberhardt, this court already established that reckless assault and battery is a violent crime under the force clause. And so if assault and battery with a dangerous weapon consists of intentional and reckless acts, and if reckless is considered violent under the force clause, then the statute as a whole is considered violent under the force clause, and therefore it's categorically a violent crime. Therefore, a copy of the conviction record is sufficient. And that's the last point on whether the two sentencing enhancements, 10G and 10N, can coexist. The legislature is very clear in that it writes in 10N that 10N is an additional further punishment to be served from and after, where 10G replaces the punishment for 10A. This is different than what this court found in Richardson, where you had 10D and 10G, which both were related to the defendant's prior criminal history. The legislature wasn't clear in the plain language as to whether these could coexist or not, and so the ambiguity led to the rule of lenity there. Here it's different. The legislature writes right in 10N, further punishment from and after, and 10G replaces. And the trial judge demonstrated that he knew how to apply both statutes, as when giving the sentence, he said, I'm consolidating 10A and 10G, and then giving the additional 2 years of probation on 10N. Thank you, Your Honors, and the Commonwealth is prepared at this time to answer any questions.
Okay, Justice Link.
I don't have any questions. Thank you.
Justice Gaziano.
No questions. Thank you, Chief.
Justice Louis.
On assault and battery, reckless assault and battery, it's certainly a violent crime. You have to prove a pretty serious bodily injury that isn't trifling and interferes with the victim's health and comfort, and it's not enough that they're just shaken up. But what about the requirement in the ACC about targeted at the person of another? Targeted at the person of another.
Yes, so I recognize my brother's argument that phrase modifies the use of physical force. But the Commonwealth points out that this court, particularly in Eberhardt, really focused in on the phrase use of physical force. And while the First Circuit has addressed the matter, the appeals court did say in Widener that no Massachusetts court has gone that far in terms of reckless battery. The Supreme Court in Beausine did address why reckless battery. This was not necessarily in relation to the ACCA, but it was talking about a statute of a main statute, which was possession of a firearm after having been convicted of a domestic violence case. And it ruled that reckless domestic assault qualified as use of physical force. And it pointed out that in Leo Cal and versus Ashcroft, the Supreme Court talked how accidental is certainly different than reckless. And what makes reckless behavior different, the Supreme Court in Bocine said that it's the harm such conduct causes is the result of a deliberate decision to endanger another. So you still have an intentional, deliberate act that is done in a way that endangers another. And what makes it reckless is the understanding that there are people in harm's way. And so the phrase against another in the Commonwealth's view still applies because you're still endangering another, and it's the knowledge or the person should have the knowledge based on the circumstances that there are people in harm's way.
Okay, thank you.
Justice Budd.
No questions. Thank you.
Justice Schaefer.
No questions. Thank you.
Justice Kafker.
Mine's the same question I asked your brother. It seems like we've added a new element, and I'm just not sure how we can add a new element and not make it retroactive. I was looking at the cases cited by your brother, Henson and Ennis. And in Ennis, we write, Henson did not add a new requirement to the elements of the crime, and therefore we're comfortable there saying it was prospective. But I'm just, how can we add an element and not apply it retroactively? I just don't know how to do that.
So, Your Honor, the key here is what this court talked about, Dagley, and again in Eaton, which this court adopted the language in Dagley, that this court is not constitutionally required to apply a new statutory interpretation to cases on collateral review.
I understand that as a general matter, but when the newer statutory interpretation says that the statute has this element, and we never required proof of that element, don't we have to apply that retroactively?
No, because in this court talks about how whether it's novel is one of the factors that this court talks about in American International Insurance, that holdings can be applied prospectively only when there's been a substantial departure from prior precedent. And so I believe it's been stated before that no trial judge was instructing on knowledge prior to the holding in Brown. This, other aggravating factors that, such as drug weight or school zones did not have a mens rea that attached to them. Mens rea attached to the underlying crime. So this really was a substantial departure from prior precedent, and it leaves some inequity in that, a litigating party is left to divine what the future holdings of the law may be. And those are factors, inequity, a novel new rule that this court has said can factor into whether they decide, understanding that this court has the discretion to decide whether to apply a new statutory interpretation retroactively.
Okay, thank you. No further questions.
I have only one or two. Let's focus on the ACC. I guess two questions. Where we have previously in other cases looked to the federal interpretation of violent crime, why should we not do the same here?
This court has already spoken on the issue in Eberhardt.
Well, I know I was on the court in Eberhardt, and there the focus was, well, it could have been offensive battery. I don't think, frankly, we had any discussion about this particular issue. So I understand what Eberhardt says, but I don't think anybody raised or discussed the issue of the importance of the phrase against the person of another. So I know what it says, but I don't think it necessarily reflects a careful consideration. I don't think, and of course that was not the issue in the case, since we didn't know whether it was or not. It was an offensive battery. So put aside Everhart for now. I know, yes, you can. I mean, certainly we said that in Everhart, and I understand that. But more generically, why should we depart from the federal interpretation?
The federal government has instituted their own ACCA, and I recognize that the language is by and large the same. Massachusetts has implemented their own, and this court stands to interpret it how they wish to interpret it, and certainly the federal courts can be looked at for guidance. However, this court, as it's demonstrated before, can determine that they interpret their own Massachusetts ACCA differently than the federal court. And for reckless assault battery, the use of physical force really is the important part. But I understand that there is that modifying phrase against another. But the Commonwealth would argue that still plays a factor in reckless assault battery with a dangerous weapon, because it really is still a deliberate decision to endanger another. I think that satisfies that part of the sentence.
Okay, and if we don't find that it categorically is, again, I have no idea whether or not we will. We'll find out later. But let's assume for the moment that we don't find that the mere conviction by itself is categorical. Then we move to the modified categorical approach, and we try to look to see whether we can discern whether it was intentional or reckless. Correct?
Correct.
Is there anything, I've not gone back to look to see what there is in the record. Is there anything in the record, if we were to apply the modified categorical approach, that would say, well, it's pretty clear that this was not a reckless battery, but an intentional battery?
No, Your Honor. There was no testimony as to what actually happened that led to that conviction.
I have no further questions. Any questions of the other justices? Hearing none, that concludes the argument in this case. I thank all counsel, and I thank my fellow justices, and we will figure out when we're going to stumble on the case. Thank you.